How to avoid paying taxes on alimony. People want to keep their finances steady and wonder how the law treats alimony at the state and federal levels. Alimony, also called spousal maintenance, is money one spouse pays the other during or after a divorce. New York courts look at each spouse's income, the length of the marriage, and daily needs. Support is meant to help a lower-earning spouse handle bills while life shifts from married to single. Temporary maintenance covers the months while the divorce is pending, and post-divorce maintenance begins after the final judgment. Judges can adjust amounts based on health concerns or child care costs and may deviate from standard formulas if strict application would be unjust. The Tax Cuts and Jobs Act of 2017 changed how alimony is taxed. For divorces finalized before January 1, 2019, paying spouses could deduct alimony from federal income and recipients had to report it as income. For divorces finalized on or after that date, the deduction for payers was removed and recipients no longer report alimony on federal returns. New York did not adopt this change. Under Tax Law Section 612(w), the payer still deducts alimony and the recipient must include it in state taxable income. Because state and federal rules diverge, payers sometimes seek lower payments to offset federal tax burdens. There is no lawful way to evade taxes on alimony. For agreements executed after December 31, 2018, federal law no longer taxes alimony received and there is no deduction for payers. New York still taxes the recipient and allows the deduction. To reduce the state tax burden, you must negotiate an agreement that takes the overall tax impact into account so that payments and income are allocated fairly. Recipients should set aside money for state taxes and make estimated payments, since New York adds post-2018 alimony to state income. Using alimony to pay medical or educational costs or to fund investments with favorable tax treatment may lower overall liability. Courts have discretion, so providing financial information may persuade a judge to adjust amounts based on tax burdens. Filing status affects alimony calculations. Filing jointly during a pending divorce may offer higher thresholds and access to certain credits, while filing separately could be better when spouses have unequal incomes or concerns about shared liability. Finalizing a divorce before December 31 lets each spouse file as a single taxpayer for that year. If the divorce is pending on that date, you may choose between joint or separate filing, which affects tax liabilities. Timing the finalization of a divorce and deciding between lump sum or periodic payments should be considered carefully. Negotiating alimony requires full financial disclosure so that neither spouse agrees to an unfair tax burden. Spouses can structure payments to balance tax obligations over time, and mediators or tax advisors can help craft arrangements that meet both parties' needs. Working with a knowledgeable attorney at a law firm provides guidance because the lawyer understands how New York law interacts with federal tax rules and can suggest lawful ways to minimize taxes. Alimony and taxes are complex issues that should not be handled alone. An attorney familiar with New York family law can explain how state and federal rules differ and advise on options that support long-term financial stability. The Law Office of Richard Roman Shum, Esq., located at 20 Clinton Street, FRNT 5D, New York, New York, 10002, provides guidance on spousal support matters. To speak with a lawyer about your case, contact the law firm at 646-259-3416.